is Immigration Customs Enforcement. That's the entity that was created after INS was dismantled in 2004. ICE likes to pick on our industry. We have to know that. We, along with the construction industry, janitorial, maintenance, we are the employers that ICE likes to look at. So we have to be ready to be able to say that our I-9s are in good order. We have a brand new I-9 that came out on January 23rd of this year. Folks, make sure you're using the new I-9. If you're using the old I-9 for employees that are that you hire now, you can be fined for using the old I-9. Also, there's a lot of restaurants out there that have picked up the Spanish language I-9, and you have to read that carefully. It's not valid unless you're in Puerto Rico. So if you're using the Spanish version of the I-9, you cannot use it unless you're in Puerto Rico. So make that, those are the big mistakes that I see restaurants engage in. They're either using the old I-9 or they're using the Spanish language I-9. And it sounds technical, but guess what? The I-9 is very technical. So make sure you're using the current form. It's a 2-page form. It used to be a 1-page form. Folks, remember, you only use the new form for new employees hired as of today or as of the 23rd of January. You don't have to go back and redo the I-9 for employees that were previously employed by you. We get calls on that all the time. You don't redo the I-9 just because a new form comes out. You just use the new I-9 from the effective date forward. The I-9 has 3 parts to it. The first part that the employee completes, the second part that the employer completes, where the employer swears under penalty of perjury that he looked at original documents and that the documents were those identified on the I-9. And then the third form, or the third section, Section 3, where the employer has to re-verify certain documents that have expiration dates on it. You heard me say certain documents. You don't re-verify driver's licenses under Section 3. Remember, that does not trigger a re-verification obligation. Also, many restaurants are mistakenly asking employees to re-verify permanent resident alien cards that expire. That is one of the most common errors I see, and it's flat out wrong. You do not have the right to ask an employee to present a new permanent resident alien card when it expires. It's complicated, folks, but I'm not just giving you a best practice. If you ask Pedro, your permanent resident alien card expires in January, so I need a new document. Guess what? You are engaging in document abuse. You can get fined for that. Let me make this point real clear. The notion is once a permanent resident alien, always a permanent resident alien. And you don't have the right to ask him to re-verify. I said it was complicated. It's so complicated because remember, if Pedro is a DACA, a Deferred Action for Childhood Arrivals, DREAM Act kid, he does have a limited work authority that is only good for 2 years. So in Pedro, the DACA case, you do have to re-verify under Section 3. But in Pedro, the permanent resident alien, you don't have the obligation to re-verify. And in fact, if you do, you're engaging in document abuse. Folks, if you didn't realize it now, there's a catch-22 situation for employers. If you don't take the I-9 seriously, ICE is going to be down your throats, and we'll go to the next slide, and you're facing fines. But if you go overboard, if you decide, hey, I'm going to make sure that everyone has a DHS-issued document, or I'm going to make employees re-verify every year, then you've gone overboard and you have another government agency to deal with, and that is the Department of Justice Office of Special Counsel. And yes, they do fine employers. They do go after employers. So it's enough to know that you do have you're in a catch-22 situation. You have to make sure you understand that, because if you don't take it seriously enough, you got ICE breathing down your back. if you go overboard, you have the Office of Special Counsel breathing down your back. So you have to catch that medium point that gets you in compliance with both laws. Both laws are very serious. Both laws tend to focus on our industry. Now, let me talk a little bit about the Latino workforce, because that is what is getting a lot of attention right now. My expertise is focusing on companies with large Hispanic workforces. Well, the Latino workers make up only 16% of the total U.S. workforce. So in some sense, you might say, well, why is it such a big deal? You all know why it's such a big deal, because yes, they may only comprise 16% of the national workforce, but they comprise a large percentage of certain industries and even certain occupations. Certain occupations have become entirely Hispanic. If you go back and look at food prep workers, they're about 60% Hispanic. Drywall carpenter, that's about 70% Hispanic. So some positions have become almost entirely Hispanic. And we know that certain parts of our restaurant, if you talk about the back of the house, that part can be heavily Hispanic. And we know also that a certain number of Latinos are undocumented. So that's what kind of brings it to our attention. And so let's go on now, and I'm going to talk about 3 areas of immigration compliance that you all need to be familiar with. The first one is no-match letters. So no-match letters are starting to be issued again by the Social Security Administration. And this doesn't mean you have to terminate the employee, but you cannot ignore the no-match notice. We know that Social Security says you can take up to 45 days to address the issue with the employee. And it may be a conversation like this. Again, I'm going to use Pedro. Pedro, we got this notice from Social Security. It says that your number does not match with your name. You have 45 days to correct the issue. Now, what may happen is Pedro may come back and say, you know what? My name's not Pedro. My real name is Federico. Here's my new documents. You have 45 days to address that issue. You cannot ignore the issue. But if when you confront Pedro, if he says, you know what, I don't have good documents, my documents are fake, and he doesn't present new documents, you have to terminate Pedro. There's no wiggle room, because Pedro has admitted that he is not authorized to work. Let's go to the next slide. This is a scenario that kind of relates to the previous one. This is what we call NCIS, New Confessed Identity Scenario. Carlos changes his name to Juan, and he tells you, hey, my name's not Carlos, my real name is Juan. What do you do in that scenario? Folks, it's happening all the time. You heard me mention DACA kids. DACA are the DREAM Act kids. There's almost 1 million of those kids. They were working prior to being given the work authority document, but they were working under a different name or a different social. So what do you do in this NCIS scenario? It's real simple. You complete a new I-9 when Carlos tells you that his real name is Juan, and you ask him for an explanation. What happened? He might say, well, I'm a DACA, I got my DACA permit. He might say, I went to Ciudad Juarez and I got my provisional waiver granted. You ask him for the reason, how he was able to change. Then you complete a new I-9 and you save the old I-9 with the new I-9. This is vital. You have to keep the old I-9 with the new I-9 to prove that you looked at original documents the first time and you were fooled, and that you were fooled by the employee. Now, from the employee's point of view, candidly, he would prefer that you throw away that old I-9 because that proved that he was using fake documents. But here, in this instance, your interests and the employees are not the same. You have to protect the company. So you have to keep the old I-9 with the new I-9. The question with this NCIS situation that arises also is, well, do you have to terminate one? your employment application says you will terminate for any misrepresentation. You need to look at that. Most employers in this situation are not terminating the employee because he's been with the company a while, he's been doing a good job, and this is different from a misrepresentation of a criminal background. So that's something to consider. Also, if you're in California and you want to terminate Juan, you can't do that because California has a law that says it's illegal to be terminated if you are changing if you're coming forward with your legitimate identity. So that's probably one good thing to come out of California with regard to employers, because it gives us the protection we need to keep these workers. But bottom line is you don't have to terminate employees in this situation, but you may want to look at your handbook right now to make sure that you address the issue and give yourself the flexibility to keep Juan or Carlos, Juan, previously known as Carlos. Let's look at the next slide. This is a very important issue that is affecting a lot of restaurants. So this lady named Margaret calls your restaurant and says, "Sir, I've never worked at your restaurant. I'm from Pennsylvania. I'm getting kicked out of my government housing project because you are reporting revenues to my number." That is happening a lot. And what happens, unfortunately, is many times restaurants ignore this lady. They pass her to payroll. They don't return her call. So guess what happens? She gets kicked out of her government housing because you're reporting revenue to her number, and she's earning, according to IRS, she's earning money that disqualifies her from living in government housing. So what does she do? She goes to a pastor, and the pastor puts her in contact with a congressman, and the congressman gets ICE at your restaurant, all because you ignored this lady from Pennsylvania. That's a real-life scenario, folks. I've dealt with it about 4 times, and it would have been totally avoidable had the restaurant bothered to call the lady in Pennsylvania back and say, "Ma'am, tell me what the issue is." If she gives you the number and says, "Look, this number belongs to me," you have a very simple duty. Go and investigate. If the person with that number is still at your restaurant, you interview him. You confront him. If he admits that it's not his number and that he's not authorized to work, you're going to have to terminate him, but at least you've solved the problem and prevented her from getting ICE at your restaurant. So we have to take advantage of this low-hanging fruit and protect our restaurant. If we get calls like that, we have to be proactive. Also, terminating the person is a good start, but you also have to file an amended W-2 report to correct that the earnings did not belong to her. So I can send you a little guide, step-by-step guide on how to file one of those amended forms. But that's very important. Well, let's talk a little bit about the new administration and immigration compliance, because I mentioned that at the intro. That's what our employees are very concerned about. That's what business owners are concerned about. What is Trump going to be like for restaurants with regard to immigration? Well, look, folks, I'm not going to be an apologist for Donald Trump. I've had that role before. Any of you all that are curious can merely Google Jacob Monty and Trump, and you'll see that Mr. Trump and I have somewhat of a history. I was advising the campaign for about 2 months. I was very happy and proud to do so, and then he gave that disastrous Phoenix speech where he repudiated everything we had been talking about. Now, after he won, I went back, and I am now also still trying to influence the campaign. But this is what he said he was going to do with immigration. And we are seeing that he has not delivered on everything. And that's good. He said in Phoenix that he was going to end DACA. He's now said he's not going to end DACA. So that's good news. He's said that he's going to increase the number of ICE agents. That he's followed through with that. He appears to be pushing for an increase in his budget. He's called for mandatory E-Verify. If there is an immigration bill, it'll probably include mandatory E-Verify. He's called for stricter H-1B visas. Those are high-tech visas. So we've seen a mixed bag on Donald Trump. Of course, he's called for the wall, and he seems to be moving in that direction. But there's another myth out there, is that E-Verify solves all problems. Folks, I love E-Verify. E-Verify is free. It gives you civil and criminal immunity for anyone you in good faith run through the system. But maybe the best thing about E-Verify is that you don't have to run your current workers through there. You only run new workers hired after the effective date of the E-Verify Memorandum of Understanding. So a lot of employers have jumped on E-Verify to kind of be proactive and to protect themselves. That might be a good idea, but remember, folks, it will be very hard to hire if you are on E-Verify. And if your competitors are not on E-Verify, they will have a huge advantage over you. Now, another thing about E-Verify, and listen closely, it does not work. It doesn't pick up identity theft. Let's go to the next page. How many of you all have seen this ad? Todd Davis ran this ad in 2004, 2005, and he was promoting his LifeLock identity theft service. Well, after this ad started appearing, we started to see 137 Todd Davises. Some of them were not even 5 feet tall. They were Guatemalan workers working in different meatpacking plants throughout the country. They didn't even speak Spanish. Some of them they only spoke indigenous language. Why was this happening? Because when Todd Davis put his social out there, people were able to make IDs that said they were Todd Davis. Now we see on this slide, that's not Todd Davis, this is Todd Davis. So E-Verify has a glaring hole in it. It doesn't pick up identity theft. We deal with employers all the time that have been on E-Verify for many years, and yet they still have undocumented workers at the workplace. So bear that in mind about E-Verify. It does have some holes in it. I'm not saying it's not a good thing. It is a good thing. It is a good way to show compliance, but it doesn't solve the problem. Folks, and I mentioned it at the beginning of my presentation, the quality of the fake documents is so good that ICE is routinely fooled by these documents. We have 2 retired ICE agents that work with our firm doing audits, and they are sometimes fooled by the quality of the fake document. Let's look at this slide. And this slide illustrates that really, because we don't have a guest worker program, our free market has created one, and it's an illegal one. But it's a billion-dollar industry that brings in the workers, provides them fake documents, and this is actually a website, fakedocuments.com. And you can order different quality documents, and they will be sent to your house or to another location. And this illustrates that employers really are in a tough spot because the quality of the fake documents is so good that they don't know what to accept. And remember, if you're bold and you say, hey, Pedro, this doesn't look correct, this social looks a little off, if you're wrong, you're looking at a lawsuit or a charge by the Department of Justice. So again, it is hard. The question I always get at this point is, well, Jake, well then what should I look at? Well, look, we recommend you should copy documents if you are, copying documents is not required, but it's a good way to show good faith. We recommend you copy the documents the employee presents for Section 2 of the I-9. And you should look at the document. If it has a misspelling on it, you shouldn't accept it. I mean, that's the standard we're held to. You don't have to be a document expert, but you do have to know how Ohio is spelled or how Department of Public Safety is spelled. That's the standard you're held to. Now, the good news is normally we don't see those types of bad documents. The quality of the fake documents is pretty good. You don't see that. But occasionally we do. And my message to you is if you see something with a misspelling on it, don't accept it. If you turn over a document and it says novelty item, you should not accept that. That's the standard we're held to. We're not held to the standard of a forensic document examiner. It's a reasonable person standard. So if the documents don't have misspellings on there and they look like the person who's applying for the job or who's been offered the job, then you should accept it. That simple. All right. Now, we're going to go to immigration, family, and friends, and I have to give you the warning here. You have to be very careful in talking about immigration with your employees, because if you cross the line and learn too much information, you cannot unlearn it, and you're creating a big problem for yourself personally and for the employee. So bear that in mind. Probably the best illustration of this is a real-life example I had. I was doing an audit on a meat processing facility, and the audit was going great. The I-9s were perfect. His policies were perfect. His OSHA logs were perfect. Everything looked great. At the end of the interview, as we were concluding, he tells me, Jake, you know what my secret is? I bothered to learn everyone's real name. And I looked at him, not really understanding what he was saying, and he pulled out this laminated sheet, and he says, look, all my key employees, I know their real name. You see that guy, Federico? That's not his real name. That's the identity he bought in Denver. His real name is Jose Luis. And he proceeded to tell me everyone's real name. And I was just in shock. This was the plant manager having learned way too much information about his workers. And once you learn that, you can't unlearn it, folks. This is an example of too much information being a bad thing. And what's worse is he had it written down. Terrible situation. Remember, if you don't know for sure, you don't have to act. But if you know for sure, you do have to act. You know, the question I always get here is, what if I get an anonymous complaint saying, you know, Jose's undocumented? Do I have to investigate that? Well, in that scenario, my answer is no. If they're not willing to give you more details, you don't have to investigate. But if you get a call from Jose's ex-wife that says, I know Jose works there. I know he's undocumented because I was trying to fix his papers. He's not a good person. He's using a fake number. Those are details that you're going to have to investigate. And in that case, you're going to have to confront Jose because you have a real person who's identifying the complaint. It's not an anonymous complaint. That does trigger an obligation to investigate. Having said that, I am going to give you all some information that you can share with your staff members. Remember, just because your staff is concerned about immigration doesn't mean they're admitting that they're undocumented. We know that most undocumented families have at least one person who is documented. So there's a lot of mixed status families out there. So just because Pedro has questions about DACA or about immigration raids isn't an implicit admission that he's undocumented. He could be worried about his wife, about his kids. So bear that in mind. Just because someone acts concerned about Trump or about immigration, that's not an admission that they're undocumented. But be careful. Remember, we have to be ready with our canned waiver language that basically says, Maria, I care about you. I want to be here for you. You know, we have this information, but remember, if you tell me too much information or information that contradicts with the I-9 I have here, I would have to act on it. So just bear that in mind. I know it's a tough thing for us to do to sound like lawyers like that, but we have to protect ourselves and we have to protect the employee too, because if you admit that you know that they're undocumented, you can't keep them at your restaurant any longer. Having said that, I think you all can navigate this. Let's dive into immigration for family and friends. So we're looking at the executive order of January 2017. we call it the Bad Hombre executive order. And let's take a look at who it's targeting. Threats to public safety. This would be someone with an outstanding arrest warrant. We know that they're focusing heavily on folks with DWIs because that affects public safety. Any alien charged with any criminal offense, whether it's a crime of moral turpitude or not. Any alien charged with a crime is automatically going to be on the Bad Hombre radar screen. Any immigration violations. If an alien has a prior order of deportation, he is now a priority now. You know, the media made a lot of hoopla over the very sad case over Guadalupe Garcia from Arizona. The lady seems like a very nice lady. And, you know, she was deported back to Mexico. It is very tragic. However, what the media did not report very well was that she had already been convicted of a federal crime. She had already been ordered deported back in 2009. So it wasn't Trump targeting her. This was someone who definitely fit within the Bad Hombre executive order. Now, I don't agree with it, and I don't think she was a threat, but it's important to note because Univision and Telemundo keep trying to create hysteria with the Hispanic community, and I believe it's misplaced at this point. Now, I'm not saying that there aren't some bad elements in the Trump administration that appear to be excited about deporting people and maybe engaging in mass deportations. I'm just saying that today it's not happening. And if you look at this executive order, these are the people they're targeting. And as I said at the beginning, these are the same people that would have been targeted under the Obama administration as well. So if you fit on this list, you do have something to be concerned about. Generally, if you don't fit on this list, you should not be overly concerned about it today. Now, one thing that was announced in this executive order was if you are a, quote, bad hombre, you could be subject to expedited removal. That's not a good thing because that is very quick deportation process. Now, this is intended to expedite the removal of people that have been here a very short time. So this is why we are advising our clients that are individuals, you need to keep on your person documents that prove you've been in the country longer than 2 years. More time is better, so that they can't use this expedited removal feature on you. Normally, the expedited removal feature is only used on aliens along the U.S.-Mexico border. But under this executive order, it's been expanded. So the message to employees that are undocumented, and again, we don't know that they're undocumented, but the message to individuals that are undocumented is you need to keep on your person some proof that you've been in the country longer than 2 years. What is that proof? It could be telephone records, wire transfer records showing you've sent money back to Mexico, check stubs, anything that can prove you have longevity here in the U.S. And you should take pictures of that, keep it on your cell phone, and that will prevent them from being able to use this expedited removal procedure for you. So that's good information that you could, pass on to people that are generally concerned about this. Here's an important part. We're on Bad Hombre executive order. Folks, you need to have in your Rolodex a good immigration lawyer and a good criminal defense lawyer. Don't just pick somebody with the biggest Yellow Pages ad or Google ad. Pick someone that has experience, do some investigation. On the immigration side, you want someone that is a member of AILA, the American Association for Immigration Lawyers. You want them, if possible, to be board certified in immigration. On the criminal side, you will get asked, hey, I need a good criminal defense lawyer. Don't recommend your brother-in-law if he's not good. Find someone who is very good. Remember, U.S. citizens can plead guilty to all sorts of crimes and nothing happens. But if you're an immigrant, you cannot have a serious crime that you admit to, because that automatically makes you eligible for deportation. So remember that. So again, we believe that the actual alien should always have documentation showing that he's not a new arrival. If arrested, the alien should not plead guilty to any crime without understanding the serious consequences to it. They should hire a good criminal defense lawyer, and they should consult with an immigration lawyer. All right, let's look at DACA. DACA, you've heard me mention this before. DACA is still in effect. This is, even though Trump said he was going to repudiate it, he has not. And it seems like he's indicating that he wants to give a permanent solution for the DACA kids. That is one bit of good news, again, that the Spanish language media is not even mentioning. Look, I'm not apologizing for Trump, but he at least is saying on DACA he wants to provide a solution, and that means if you have people that are eligible for DACA, they should apply for it. He made a policy change on DACA, and that's a good thing. You know, if you have an alien who is eligible for DACA, they should apply for renewal within 150 days. Also, DACA kids, and I call them kids, it's really young adults. I mean, they could be you know, as old as 34, 35. They need to file an AR-11. That means they have to update Department of Homeland Security on their address. If you know a DACA kid and he has authority to work in the U.S., that's what DACA gives them. It doesn't give them a visa or legal status, but it does give them authority to work in the U.S. One of the obligations they have is to keep an updated address on file with DHS. That's important. If they don't file an updated AR-11 every time they move, they will have a problem, and they will lose, or they could lose, the DACA protection. Let's go to the next page. Also, in order to be eligible for DACA, you have to have a clean criminal record. So, you know, DACA kids cannot be engaging in risky behavior like theft, DWI, etc. So, again, DACA is a good thing. It appears like it's not going anywhere. Let's look at the next slide. And we can't emphasize this enough. If you're a DACA recipient, and there's almost 1 million of them out there, you can't be involved with drugs, driving while intoxicated, public intoxication, theft. You really are on a short leash, and you have to behave yourself. It's very heartbreaking for me to have to get involved in a case where you have a DACA person who's accused of shoplifting or DWI, and those are very tough cases to deal with. So, again, if you're a DACA kid, you've got to keep your nose clean. So let's go to the next page, and this is really maybe an unintended consequence. I don't know that President Trump realized this, but what all of this rhetoric against immigrants has done is that it's caused people to want to become citizens in a big way, and we are seeing naturalization applicants or applications skyrocket. And this is, again, something that's happening today. So you may get asked, and this is a good example of someone who asks you about a citizenship question is clearly not undocumented, because you can't become a citizen unless you're a legal permanent resident. But here is a basic slide showing what's required to become a citizen. You have to have been a permanent resident for at least 4 years, 9 months. You have to have physically resided in the U.S. for 2 years and 9 months. You have to have good moral character. You have to have physical presence in the U.S. And you have to pass a naturalization exam. And this exam is not a cakewalk, folks. I challenge you all to look at these questions. It will mess you up if you don't study for them. It'll mess U.S. people, U.S. citizens up. It's a civics exam that involves answering up to 100 different questions. You're not usually given 100 questions, but you're given different combinations of 100 questions. You have to show reading and writing in English. You have to show some basic conversation skills. And we are seeing people in mass look into becoming citizens. Okay, the next slide is parole in place. This is something that is still in effect right now, and this would affect the parents of U.S. citizens if the U.S. citizens are serving in our armed forces. So let's go to who qualifies. This is an example. So you have Jose is a U.S. citizen. He's serving in the Marines, and he his parents are undocumented. So Jose petitions for his parents. He can do that when he turns 21, but his parents, because they entered the country without inspection, they would have to go back to their home country to regularize their status, and they would have to ask for a waiver there, and that waiver may or may not be granted. They could get stuck in Mexico for a number of years. So what PIP, parole in place, does is it says, look, because you're serving the country, we're going to give a special benefit to your parents or to your wife or to your children, and you can adjust without leaving the country. And that's a huge benefit. That's something that not a lot of people are aware of, but it is a benefit. You know, I hate the term anchor baby because it's a lie. You can't be an anchor baby until you turn 21, so there's no such thing as an anchor baby. In this case, Jose, he can't even petition for his parents until he turns 21, and at 21, he's certainly not a baby, and he's serving the country, so, you know, they give him a special benefit. But it's something that's not likely to be taken away. Trump has spoken favorably of it, so parole in place is something that might exist. The Rainbow family, this is a real situation. We are having people regularize their status based on their marriage to a person of the same sex. This was made possible after the Supreme Court defense of marriage case, and it is happening. It happens quite frequently. So that is another feature that exists right now, and it is enabling spouses of U.S. citizens who happen to be the same sex as the spouse to get their permanent residency. All right, let's talk about provisional waivers. And I want to mention this now because I hate the term, you know, why don't they do it the legal way? There is no legal way. There are over 1 million people who are married to U.S. citizens, but they're still undocumented because they entered without inspection, and they would have to go to their home country and ask for a waiver. We do have this provisional waiver procedure where you can apply for the waiver here. You still have to go to your home country, but you apply for it here, and you have a good indication that you're going to be allowed back into the country. So that is still on the books. U visas are still possible. We're now on U visas. This is for victims of crimes or witnesses to crimes. They can use the U visa route. I mention all of this under the friends and family scenario because it is, when people say, well, why don't they do it the legal way? There's not very many legal ways to regularize your status. I wanted to highlight these because these are some of the ones that exist, but many people don't qualify for any relief, and you should know that as well. This is the only problem in America that you can't throw money at and the problem goes away. There are many people who don't fit within any of the categories. I need to mention notario fraud because a notario in Latin America is like a judge. A notario here in the U.S. is really nothing but someone who is over the age of 18 and files a request with the state. There are a lot of unscrupulous notarios out there scamming immigrants, getting them to pay huge sums of money, and what's worse, they get them to file documents that cause them to be deported. So you should know about notario fraud. You should encourage people not to use notarios. You should refer them to qualified immigration counsel. That's the point here. Now, I've talked a lot about, you know, the Trump era and how it's going to be more enforcement. We're going to see more I-9 inspections. We are already starting to see that. Trump has promised that that's generally not good news for restaurants. The one good bit of good news for restaurants is the salary increase rule that would have gone into effect last year was stopped by a judge, and it does not appear that Trump is going to reissue that. That would have taken the salary rule from $455 to $917 per week. Basically, in order to still be salaried exempt, you were going to have to earn at least $917 a week. That rule by Obama was put on hold, so that's good news for the restaurant industry. That rule was going to cost a lot of people, it was going to cost them their exempt status. And some restaurants already moved people to hourly because they thought that was going to happen. So that's good news. We may see the salary rule increase. Some people think that $455 per week as a minimum is too low for salaried exempt. It may get increased, but it's not likely to get increased as much as Obama was calling for. So that's good news for restaurants. I have a slide here on Fight for 15. We are seeing unions continue to target fast food restaurants. That is likely to continue. That's their Fight for 15 initiative. Their goal is to have a salary or an hourly wage of $15 for fast food for all workers, really. One thing about the Fight for 15 movement, sometimes we are seeing unions make, notario-like claims. They are promising immigration benefits if they sign the union card. That's just a lie. It's very underhanded activity that unions are engaging in, but it is happening. So you should know that is not possible. Another bit of good news, mandatory arbitrations that prohibit class-wide relief are very important. I'm a big believer in them. You do not want to be facing 12 angry jurors that hate companies. You are much better off having your employee disputes resolved through binding arbitration. We're going to have a Supreme Court case here in a couple of months that we believe will decide definitively that mandatory arbitration agreements that prohibit class-wide relief are in fact very legal and don't violate the National Labor Relations Act. So that's another bit of good news that we're expecting for restaurants. We are seeing so many class action cases out there where one employee files a complaint on behalf of all employees. These are very expensive lawsuits that can bankrupt restaurants. So we are big believers in mandatory arbitration agreements. If any of you all want these, we give them to the restaurant industry free of charge. We have them in English and in Spanish, and we encourage you all to protect yourself. On Obamacare, this is my last real big topic, is a lot of restaurants have kind of gotten hooked and believe that Obamacare is gone and they don't have anything to worry about it. Folks, it's not gone. And this is a real example of an employer that was fined for not having insurance. So remember, Obamacare is still here. It has not been declared illegal. Employers are still being fined if they don't have insurance and if employees are going to the exchange. So if you're not in compliance with Obamacare, you need to consider getting into compliance ASAP. This is an example of an employer, actually a restaurant, who was fined. His fine was about $7,000 per month, and we've since got him into compliance. But you want to get into compliance. If they make a change to Obamacare, that's fine, but you want to get into compliance, even if it means only offering a skinny plan. You want to do something. Paying the fine is just dumb, because you don't get a deduction on your taxes also. Bear that in mind for the fine. Okay, the last thing we're going to talk about is unemployment claims. I included this because we're getting a lot of restaurants that are saying, Jacob, it's still really hard to win unemployment claims, and I agree with you, it is. The key is you got to have documentation, and you can win these cases, but it has to be in writing. That's my presentation. I will answer any of the questions that you all submitted, and thank you for your attention.
Thank you very much, Mr. Monty. We appreciate your time. Does anyone have any questions? If you do, please use the questions panel on your screen to send it. Mr. Monty, I have a question that was raised at a previous webinar, and maybe you can briefly explain. What should a restaurant owner do if ICE conducts a raid? What steps should they take at that very moment? Well, what are their rights and responsibilities at that point?
Well, great. I will send everyone who wants a document we've prepared that kind of outlines 10 steps employers should take. One thing, we have to get the language right. Raids are possible, but they would be very rare. Raid means a bus, a ICE agent, often working with law enforcement, where they are designed to arrest people and take them from the workplace. I'm not saying we won't see raids. I'm just saying that I have not seen raids to date. The last time we really saw coordinated raids was really in the Bush administration. What we saw in Obama was what we call silent raids. They were called I-9 NOI, Notice of Intent to Review I-9 document raid. And we called them silent raids because they never came with buses or with sheriffs. They looked at the I-9s and they determined who was undocumented, and then they made the employer terminate the undocumented people. The end result was the same. The employer lost to the employees, but immigration never came with buses and handcuffs. So we may indeed see raids. I think what is more likely, though, are more I-9 NOI reviews. And the way you protect yourself here is you take advantage of the 72-hour notice that they have to give you. They have to give you 72 hours to prepare and review your I-9s, and you should call a lawyer immediately after getting one of those notice of inspections. We can help. Any lawyer who knows this area can help the employer in that situation. Certain changes can be made to the I-9 during that period. Remember, you never backdate a document. You always make changes in red ink to call attention to the fact that you didn't do it right the first place. That's important to take advantage of the good faith requirement or the good faith defense. But I will send you all the 10 things you need to do in a I-9 review. Now, if you are looking at a raid where they're coming to arrest people, there you need to take a somewhat different approach, because in that case, insisting on a warrant, looking at the warrant is definitely in order, because in that case, the employer may in fact be the target of a criminal investigation, and you want to make sure that you don't hand over documents that can be used against you later. So if it's a raid, then you need to get in touch with the lawyer immediately, and you need to let the lawyer interface with ICE. If it's an I-9 NOI, you take advantage of the 72-hour period and you get counsel involved. I don't know if that addressed it, Ed, but two different issues.
Understood. Thank you. We do have a couple of questions here from attendees. One of them is kind of a housekeeping issue. Let me answer that very quickly. One attendee asked if we can get a recording of the webinar and an email of the PowerPoint. And yes, we will post a recording of the webinar, which includes all the slides, on our website later today or early tomorrow. So everyone will be able to see that. And I'll send an email to all the attendees so that they know it has been posted. The second question we have here for you, Mr. Monty, let me read it to you verbatim. What is the suggestion for places that find themselves in a situation where they don't have I-9s for employees who have been with them for over 10 years?
Great question. Don't freak out, people. It happens all the time. It's fixable. Complete the I-9 now. It will be late. We can't go back in time. But don't backdate the document. And I can't emphasize this enough. If you complete the I-9 with today's date on it, and you use the current I-9, and you put in the middle of Section 2 the actual date, which is 10 years ago, that shows good faith. When ICE sees that, they're going to say, hey, this employer is trying to do the right thing. He's not trying to backdate a document. He's trying to get in compliance. maybe the original I-9 got lost. Maybe they had a bad manager at the time who didn't realize the importance of it. It happens, folks, but you can correct it. It will be a late I-9, but having literally reviewed thousands of I-9s and dealt with hundreds of investigations, when I see that on the employer's part, they are more inclined not to fine because they see an employer who's trying to do the right thing. So the most important message is get those I-9s completed, but do not backdate the document. The other thing is, and again, backdating is bad, but backdating is very tricky also, because you have to figure out, if you were inclined to do that, what I-9 was in effect at the time 10 years ago. So, it's complicated because the I-9 has gone through about 12 different versions since it was initiated 30 years ago. So don't try to backdate. It's not worth it. It'll end up backfiring. Just complete a new I-9 and you'll be in good shape. Even if it's late, late is better than not having it.
Great. Thank you. Well, Mr. Monty, we thank you very much for your time this morning. We're over the hour, and I know that your time is very valuable, so we're going to end the webinar here. If anyone has any questions that have not been answered, you are welcome to email them to me. My email is on the El Restaurante website, but it is eddavis@restmex.com, restmex.com, and we will find the answers for you. I want to remind you again that this webinar recording will be posted on our website also. And if you would like to participate in this webinar in Spanish, or you have managers or friends who would prefer to hear this in Spanish, Mr. Monty will be delivering this same webinar at 2 o'clock this afternoon in Spanish. And if you would like to register for that, the registration link is on our website, and you can register right up until the point of the webinar. So I definitely encourage you to share that news if you have somebody who you believe would prefer to hear it in that language. With that, we say thank you again, Mr. Monty, and to all the attendees, and we hope that this has been useful. And that ends our webinar. Thank you.
Thanks. Bye.